Mr. Bowersock, anything procedurally before we proceed?
Yes, Your Honor, I object to this procedure. We have orally stated that in the prior tree trial on May 28th, 2/10, and I contend that the defendant has the right to secede, and the defendant has done that. The defendant has seceded prior to the City of Lima for preparing this in August, and the defendant has seceded in June 19th. The City of Lima received the seceding statement from the defendant.
What does that mean? What do you mean you seceded?
And that means that I seceded from the City of Lima, Ohio, the jurisdiction of the City of Lima, Ohio, and also at the same time the jurisdiction of the County of Allen and the jurisdiction of the State of Ohio. And that was done legally, and I contend that I have the right to do that. I have done so before knowing anything about this situation, and the city has been harassing me, and this is their method to further attempt to harass and control this defendant. The defendant objects.
Okay.
The situation we're at now is that the court has declared these to be a nuisance. What do we do with it? And in thinking about this, in terms of the responsibility of government to its citizens, the City of Lima has a responsibility to the neighbors in the area of Mr. Bowersock, as well as responsibility to Mr. Bowersock himself. And we want to try to recognize that and afford him the opportunity, even though, as indicated in the pleadings before this case, before the court, Mr. Bowersock has had literally over a decade of opportunity to correct this situation. He has intentionally failed to do so. That notwithstanding, I feel it's
Defendant objects, Your Honor.
Overall, I feel it's important for any order for this court to yet again provide him with the opportunity to abate the nuisance himself. That's all we're after, is the nuisance being abated. And if he can do it himself, that's great. In fact, that's the preferred method, but he's demonstrated an utter incapability and unwillingness to do so. So we would
Objection, Your Honor. The defendant objects.
You'll have your opportunity.
We would, as part of our motion, we would request that any judgment entry of the court include a provision that Mr. Bowersock have 30 days from the date of the entry to abate the nuisance himself. And that one of the requirements of that would be for the city to file with the court a statement or report.
Did he file with the court?
No, Your Honor, that the city file with the court notification after that 30-day period as to whether or not he has self-abated the nuisance.
Well.
The city will take the responsibility of doing that. The city would suggest that it's appropriate that within 10 days of the court entering the journal entry with respect to this hearing, the city provide the court with the name of a receiver, whether it be an entity or an individual that would be responsible for serving as a receiver in this case.
The defendant asked for removal of this action to federal court, and the action was apparently sent to the 3rd District Court of Appeals. I never received anything from the court, and I filed others' objection, and the court had, with prejudice, granted the partial summary judgment for the plaintiff. And the defendant objects to that procedure, and it goes right into what the defendant was saying, that on May 28th, it was a concern of this defendant whether the defendant could obtain a fair trial in Allen County Common Pleas Court. And I'm still of the idea, everything that I have asked has been objected, has been denied. And there are prejudices going on. And in the exhibits that this plaintiff has offered, the defendant noticed, and it said that there were black shingles laying around the property. And those people ought to be smart enough to know that they can turn those shingles over and see, yes, they are probably looking black, but they can see which property has the green shingles on the roof there. And that's other than my shingles that are laying there. And the wind blows them off and blows them onto my property. And the plaintiff comes out with their personnel and they look at it and they say, oh yes, you've got shingles laying around your yard. Well, I intent have, as far as repairing my roof, and I know that I have my roof to repair, and when I take the shovel and scoop those off, they're going to be all over my yard, the shingles that are on there now that I am going to repair. And I have diligently, Your Honor, been attempting to perform my maintenance duties around there. And it's other than neglect on my part, because I am doing that. And I want to be a good citizen, and I have been a good citizen in times past. And I'll show you, I've got a Chevrolet All-American trophy. And I am very proud of that, and I've had that for a number of years, and that guides my life. And what's good for Chevrolet is good for this United States of America, and I would have the court take note of that.
Very well. I take note of
The
that.
defendant recognizes that as a property owner, it's my responsibility to take care of it. And I have been taking care of it. The defendant has been with due diligence, Your Honor, and the defendant objects to him being put down, demeaned like that all the time. And the defendant has been attempting to do his work and continues to attempt to do his work. And talk on the street and call public attention to it. The defendant objects to that. And there are people who will take advantage of a person, and that's happening right now. And just over the 4th of July, Your Honor, after the fireworks ended up, I picked up at least a dozen rockets in my yard. One of them landed on my pickup truck, and it was still burning when it come down. And they were all aimed at my property, and I picked up the little after effect of those fireworks. That people in the neighborhood, we had a general fireworks display in the neighborhood.